Welcome to today's webinar. Today's webinar is a continuation of our Mass Torts marketing series, and today we're going to discuss the chemotherapy drug Taxotere. For those of you who don't know me, my name is Victoria Bluton. I'm the community manager at LawLytics. If you read our blog on a regular basis, or if you've watched other LawLytics webinars, you might recognize me. My job is to help you learn what works on the web and to keep you up to date on the latest in legal marketing technology and trends. And before we get started, I just want to remind our listeners that this webinar is part of an ongoing Mass Torts marketing series. So if you haven't seen the other webinars in this series yet and you're interested in seeing what topics we've covered, and to learn more about how to effectively market a Mass Torts practice, you can do so by visiting our website. So just go to www.lawlytics.com/webinars and you'll be able to find all of the webinars in this particular series. Before we delve into the bulk of this presentation, I want to briefly review who we are here at LawLytics, what we do, and why it matters. So you have many choices of companies and technologies to design, build, host, and help you market your law firm's website. And at LawLytics, we do all of that, and we have a lot of competition. So what is LawLytics, and how are we different? Our company is obsessed with the pursuit of the most efficient method of marketing for each law firm. And there are really two major variables of efficiency. There's your time and there's your money. And LawLytics was created to empower you to have unlimited marketing success without wasting your time and without wasting your money. And we have two different types of competitors. So on one end of the spectrum, there are full-service marketing companies. And LawLytics is built to give attorneys all of the upsides of using a full-service company, but without exposing you to the potential risks and downsides. And on the other end of the spectrum are do-it-yourself website software programs. And these are usually either cheap or free to use. And while they may not cost a lot of money, these programs tend to come with some steep opportunity costs. Attorneys will struggle to make them work, and that leaves them wasting their time and missing opportunities along the way. So while both full-service companies and do-it-yourself platforms are viable options, LawLytics offers a more practical solution for lawyers. Our company works exclusively with attorneys, and our services are adaptable to every stage of a law firm's growth. So our members can start as small as they choose and then grow as big as they decide without taking dangerous risks or committing to things that might not work. And because our software is built exclusively for lawyers, the learning curve is really quite easy, and that enables our members to add to and edit their websites and turn their efforts into new business without struggling with difficult-to-use technology. So Larry Bodine will be giving the bulk of the presentation today on the chemotherapy drug Taxotere. And before I turn the mic over to him, I'd like to quickly introduce you to him if you're not already familiar with his work. So for those of you who don't know Larry, he has a very impressive resume, both as an attorney and as a legal marketer. He's currently the senior legal marketing strategist here at LawLytics, as well as serving as the editor of the National Trial Lawyers. And Larry really has what we see as a second-to-none expertise in the evolving field of mass torts marketing, and specifically in multi-district litigation. And we're delighted that he's joining us today. So I'm going to turn the mic over to him for most of this presentation, and then I'll be coming in at the end to cover a few last topics before we close. Larry?
Thank you, Victoria, for that generous introduction. Today we are talking about Taxotere, which is a chemotherapy drug used in cases of breast cancer. There are about 1,500 cases filed against the makers of Taxotere right now before Chief U.S. District Judge Kurt D. Engelhardt in New Orleans in the Eastern District of Louisiana. This is in MDL 2740. MDL means multi-district litigation, and it's called in re Taxotere or docetaxel products liability litigation. This is a very fast-growing MDL. It was only created last October, and it's grown to 1,500 cases. Now, Taxotere is a blockbuster drug. The sales went as high as $3.1 billion with a B dollars in 2010, and it's estimated that more than 3 million women have been diagnosed or have a history of breast cancer in the U.S. That's according to breastcancer.org, a report that came out last March. And about 75% of them were prescribed Taxotere. So this is a very widely used drug. As I mentioned, the MDL was only created last October, and it started with 33 cases. By January, it was up to 700 cases, and today it's up to 1,500 cases with over 100 added in the last month. Now, this drug causes permanent and total hair loss. This is something that's referred to as alopecia. And women who have taken this drug say that they've lost all of their hair on their scalp, including their eyebrows and eyelashes, and even their pubic hair. Now, it's important to note that hair loss is a common side effect related to chemotherapy drugs. However, permanent alopecia is not a common side effect. Now, this is a really devastating condition, especially for women. Women suffer a lot of mental anguish as well as economic damages from losing all of their hair, and it includes loss of the work or inability to work due to significant psychological damage. To be eligible in one of these cases, a plaintiff must have experienced hair loss for at least 6 months or longer and must have been treated with Taxotere between 2006 and 2016, so it's about a 10-year period. The defendants are a French company, basically a global pharmaceutical company called Sanofi Aventis. It's a defendant as well as Sanofi SA, Aventis Pharma SA, and their U.S. office, headquartered in Bridgewater, New Jersey, which is Sanofi Aventis US, LLC. The lawsuits allege that the manufacturer failed to warn patients and their physicians about the risk of permanent alopecia. It's also alleged that the company knew about permanent hair loss, but covered it up. And finally, the lawsuits allege that the sales force falsely said that Taxotere was a better drug than a competitor drug that did not cause hair loss. And the allegations are primarily product liability, defective design and manufacturing, breach of express and implied warranties, fraud, and intentional infliction of emotional distress. There have been roughly 6 studies that have linked Taxotere to permanent alopecia, and the very first one came out back in 1998. And this was a Spanish breast cancer research group referred to as the GEICAM 9805 study, and it found that 9.2% of patients who took Taxotere had alopecia for up to 10 years. This was followed up by another study in 2006 by Dr. Scott Sedlacek. He is at the Rocky Mountain Cancer Centers in Denver, Colorado. And this study found that 6.3% of patients who were treated with Taxotere experienced hair growth that was less than 50%. Less than 50% of the rate that they had prior to taking the chemotherapy treatment, up to and as long as 7 years after their treatment was completed. This study involved a survey of almost 500 patients that the doctor had personally treated between 1994 and 2004 with different regimens of chemotherapy, including Taxotere. The study found that, in contrast, none of the women in the groups that got chemotherapy that did not include Taxotere developed any persistent alopecia. And the study concluded, the takeaway is that Dr. Sedlacek advised that such emotionally devastating and long-term toxicity must be taken into account when deciding on adjuvant chemotherapy programs in women who will likely be cured of their breast cancer. A warning first appeared in 2009 in Europe, and it included warnings about the potential permanent hair loss in women who took the drug for breast cancer way back in 2009. In 2012, a study was published in the Annals of Oncology reviewing 24 women suffering from alopecia induced by Taxotere. The study concluded that the women had a loss of eyebrows, eyelashes, and thinning of hair all over their scalps. And thus in 2012, they found that permanent and severe alopecia is a newly reported condition of the drug regimen that includes Taxotere. That same year in Canada, an alopecia warning was included on the drug label. Another study came in 2014, and this was at the National Cancer Research Institute's 2014 Cancer Conference. This is a group of scientists in the United Kingdom that presented a paper that found that as many as 15.8% of patients reported persistent scalp hair loss up to 3 years after they had completed their treatments with Taxotere. And in fact, 5 patients reported no regrowth of eyebrows, and the patients also reported no eyelash regrowth, and 6 had no regrowth of nostril hair, and 14 had no regrowth of hair in other parts of their body, such as their legs. And then finally, after Taxotere was on the market for 19 years in the U.S., a hair loss warning was finally included in 2015 on the labels of Taxotere sold in the U.S. Taking an overview now of the actions by the FDA regarding this drug, it began with Sanofi running its own clinical trials of Taxotere starting in 1990 through 1992. The FDA first approved the drug in December 1996 for use in lung cancer cases. In 2006, this approval was expanded to include breast cancer and also cancer of the head and neck, gastric cancer, prostate cancer, and lung cancer. And then, as I mentioned, in 2015, the FDA finally added to the safety labeling on Taxotere, and it now reads, "Cases of permanent alopecia have been reported." Interestingly, on the Sanofi Aventis Taxotere webpage, the company lists a side effect of hair loss, but it says only, in some cases, frequency not known, permanent hair loss has been observed. So the damages that the plaintiffs are seeking is that turn on the fact that, hair is a way that a lot of people identify themselves and also value themselves, particularly women, although men as well. And it gets down to the fact that we recognize people by their hair. I mean, it's a distinguishing feature of your identity. There's also intense emotional damage that's caused by losing one's hair. On the other hand, the defense is likely to argue the fact that loss of hair is just a cosmetic issue and that the complaint is really only about a person's appearance. An example of a case that is illustrative of many of the other cases was brought by a California woman by the name of Amy Dodson. She filed her case against the manufacturers in March 14, 2016 in the Northern District of California. Now, she underwent a left breast biopsy in March 2010, and it found cancer in her left breast. Now, she asserts that neither she nor her treating healthcare providers were aware of or informed by the defendants about anything having to do with disfiguring permanent alopecia, and accordingly, she went ahead and had chemotherapy that included Taxotere. And following the completion of the chemotherapy, she suffered from disfiguring permanent alopecia, which she alleges is a direct result of receiving chemotherapy with Taxotere. Here are a couple of case updates that are worthwhile noticing in the case, chiefly among which that the judge, back in December 2016, ordered the attorneys to engage in continuous general settlement discussions on a regular basis, as opposed to a detailed discovery and trial preparation. He told the lawyers this, as well as stating that he created settlement committees, and he wanted them to hold regular discussions in an attempt to establish a common understanding, potential ground rules, component parts and concepts, anticipated relief, necessary approvals, and ultimately financial details, including the drafting of all permanent documents in an attempt to resolve the matter prior to the remand of these cases or some of all of the member cases. And this was spelled out in pretrial order number 6. So Judge Engelhardt is known as a crusading jurist, and he's essentially ordered the parties to come to a settlement. Now, even though the case continues, this is kind of the ground basis of which all the cases are taking place. Now, in a couple of other developments, in last May 2017, the court allowed generic Taxotere lawsuits to be filed in the federal MDL. And this is important because half of the cases are against generic makers. And this is because Taxotere lost its patent protection late in 2010. So where we stand now is the case is in discovery. And the court heard discovery motions on August 7th and held a status conference on August 18th. And at that conference, all of the parties were to submit letter briefs to the court concerning a master discovery protocol. And then going forward, it appears that we will have our first bellwether trial in this litigation in February next year. And the parties have submitted 10 cases to the court to be considered for those bellwether trials. So in February, the judge will pick the cases, and then the trials will begin in September 2018. Taxotere's marketing is certain to come up in the litigation. The sales force of Sanofi-Aventis allegedly told doctors falsely that Taxotere was more effective than its competitor drug, Taxol. And it's interesting to note that Taxol does not cause permanent hair loss. And the lawsuits argue that Sanofi falsely marketed Taxotere by claiming it was more effective and safer than Taxol. Now, in 2008, a study appeared in the New England Journal of Medicine, and it found that the competitor drug Taxol was actually more effective than Taxotere. And following up with this was an FDA notice to Sanofi-Aventis that its advertising, saying that it was more effective, was actually false or misleading because it presented unsubstantiated superiority claims and overstated the effectiveness of Taxotere. And the FDA said that the company's marketing materials misbranded the drug in violation of the Federal Food, Drug, and Cosmetic Act. For attorneys listening to this webinar, this is actually a very good time to get involved in the Taxotere litigation. The reasons for this is that the way these MDLs work is that the court, as it's done in this litigation, will create fill-in-the-blanks forms. So there's been an amended master long-form complaint placed online that attorneys can use to draft their complaints. And there's also a plaintiff fact sheet, which goes through the medical history of the plaintiff, and this is information that is furnished to the defendants. And there's also an exemplar short-form complaint. So really, all of the documents that an attorney would need are already online. And now, one nice thing about these multi-district litigation dockets is that an attorney can be anywhere in the country, and can represent a client located anywhere else in the U.S. So the procedure is basically to enter an appearance and let the plaintiff's steering committee do most of the work. So what this tells me is the place that attorneys should really focus their effort is on getting new clients. It's still very early in the litigation. The MDL was created less than a year ago, and the cost to acquire clients is right now very low.
Thanks, Larry. So, in order to reach these potential clients for Taxotere cases, education is a very important component of that, because there are likely many potential clients in your total addressable market who may not even realize that they need to seek your services. And it comes down to how many people are out there who don't know that Taxotere may be at the root of their problem, or they may suspect that that's the case, but they're not sure that they can do anything about it. So the way that these individuals are likely to go about discovering this is using search engines to conduct searches about what they are experiencing. So if they're doing that research and they might have something that's the subject of a cause of action, or they're looking up information for a family member, if they are typing these kinds of questions into search engines, and they may not know exactly how to formulate these questions, which is why we often stress that you write like your potential clients speak. But if they're doing that, there are a lot of ways to connect with these potential clients. That is where most legal marketing falls short. There are a lot of ways to connect, but the education is really necessary. And the best way to do that is with a website, not doing things like buying leads or pay-per-click advertising. Because keep in mind that many of these potential clients may not even realize that they need an attorney yet. So trying to rank for things like Taxotere attorney or trying to buy PPC for that keyword, those things probably aren't going to make a lot of sense and aren't necessarily an efficient use of your time or your marketing budget. The best way to reach these potential clients is by providing a lot of useful, relevant information on your law firm's website that covers the points that you see here. So the symptoms, side effects, or injuries, in this case specifically alopecia, any FDA warnings that have been issued, new medical research, any possible medical options that may be available to treat the particular problem that this drug causes. That of course depends on what the topic is. With Taxotere, that may not be the case. But a question that may come up is whether or not, if you're going to start handling mass torts, whether or not you need a separate website. And that is something that we can certainly provide you here at LawLytics while giving you the same platform and control panel to work with. That part of the discussion is outside of the scope of this particular webinar. However, it's something that we have covered in depth in another webinar about the reasons to have and also not to have multiple websites. So I certainly recommend that if you're interested in that topic as you think about marketing a mass torts practice, go check that out over on the LawLytics webinar page. I believe that webinar is called Effective Deployment of Multiple Law Firm Websites. That is one of those decisions that requires some careful consideration and strategy. But to do successful online marketing, whether it is for your mass torts practice or just about any other practice area, an intrinsic part of that and of engaging potential clients and getting business online is content. So you need content, you likely need a lot of it. And if you haven't been to our website, we have a number of free webinars that carefully detail what you need to do to plan your content, to blog, to write for the web. So feel free to watch those as well. But the point here is that you need content and you're going to have to make some decisions about how that gets accomplished. So on the one hand, if you decide that you are the one who wants to write your own content, that's great. And at LawLytics, we can show you how to write that the right way, in the way that will attract your potential clients. So if you want to write it yourself, that's good. And if you use our platform to publish that content, that makes it about as easy as it gets. So it's really about as simple as using a word processor. And that allows you to develop your website into an appreciating asset for your firm without any special tech knowledge and without a lot of the extra and unnecessary expense that sometimes comes along with other kinds of online marketing for law firms. Now, if you are not going to be the one who's writing it, that really puts you in one of two positions. So either you delegate it to somebody else, and you've got to delegate it the right way to somebody who understands what you do as an attorney. And if you do that, you'll be in good shape. And in a moment, I'll talk a little bit more about how LawLytics can help you in this area. But there are a couple points to make about delegating your content successfully. The alternative in this chart is that you don't delegate. And the longer you wait to do that, the longer you wait to write that content yourself or delegate that task to someone who can do it the right way, the longer that you wait to engage your potential clients who are looking for you online, whether they know it or not, especially where mass torts are concerned, the more time you are wasting and the more opportunities you're missing. And your competitors will be getting ahead writing the content that you aren't. So we really see it as axiomatic that you need content. It just comes down to deciding who's going to write it. So choosing a ghostwriter and using one effectively for your law firm is something that I'm also going to discuss in an upcoming podcast episode. So if you haven't been listening to our podcast yet, you can always listen to it and subscribe to it by visiting www.lawlytics.com/podcast. So content's a major component of successful mass torts marketing. And aside from the LawLytics platform, which, as I mentioned, really makes adding to and editing your website very simple, content is what we really excel at doing for attorneys or helping attorneys do that for themselves. So this is a wide open field right now. The attorneys who get there first and get there with the most content and the best content are likely those who are going to see the biggest benefit. As I have said before, the internet is really the great equalizer. Marketing for attorneys has become a meritocracy. And the cost of entry to compete both at a local level and at a national level is probably not as high as you believe just based on what other marketing sources are likely to tell you. So The content department here at LawLytics that evolved out of a very specific need. We had attorneys who had been writing their own content and publishing it on our platform, and as a result of it, got so successful that they needed help to keep publishing. Their schedule simply got too busy. So that's how the department developed to assist these attorneys, and today we are writing millions of words of content for attorney websites and blogs. I am going to briefly discuss our content creation services for those attorneys who are interested. So we have an in-house content creation department that is managed by lawyers. Many of our writers are lawyers. All of them have strong writing and legal backgrounds. And all of the content that gets published on behalf of our customers who choose us to write for them does go through an editorial process where lawyers look at it before it ever gets published. So we have several levels of content creation that we provide. And these are services ranging from startup content, so there's a brand new site that doesn't have any content to get it off the ground, to creating attorney bios, to creating practice area pages, and so forth, all the way up to these really extensive build-outs of over 1 million words for attorneys who want to, over the course of a year or more, build a dominating website for a certain practice area or practices, and for certain geographic areas, and that includes mass torts content as well. But between those two extremes, we also have a la carte content. So if you are in a position where you are writing your own content and maybe you have something big coming up that's occupying your time and you don't want to have a lag in your content, at that point we can jump in, we can pick up where you left off, and sustain that publication schedule until you can jump back in and start working again. And we also have the ability to do ongoing recurring monthly blogging and content creation for our clients. At LawLytics, we really pride ourselves on having more than just a vendor-customer relationship with you. We take a lot of time at the outset to get to know you and to create a partnership that allows you to participate as little or as much as you want in the creation of your law firm's website content. So we want to know how you like your content written as far as voice goes, to get to know your objectives, and to get to know your practice area. So we look at what you're trying to accomplish and what you've already accomplished, and then we make a plan to get there. And that includes if you're ready to jump into marketing a mass torts practice. So there's a lot of opportunity there for attorneys, and we can help you meet those goals. So as we close out this presentation, I want to thank Larry so much for joining us today and providing us with his expertise. And I want to remind you that we have a lot of free resources available to you over on the LawLytics website, both in webinar and podcast form, as well as blog posts. And those are all free for you to access. If you want to learn more about how to succeed online and how your potential clients are using the internet to find you. If you have questions about your legal marketing, or you're ready to take your online marketing to the next level, or you're ready to start thinking about a mass torts practice, we are here to help and we're happy to talk with you. So LawLytics members, you can always submit a support ticket or contact us at support@lawlytics.com, and you can always call us at 800-713-0161. Non-members, you can submit a consultation request from our main website at www.lawlytics.com. Again, you can always call us at 800-713-0161, or you can shoot us an email at info@lawlytics.com.